And we are back in the Judiciary Committee and moving on to some testimony regarding S89. And so this morning, we're going to start with Stuart Schurer. I hope I pronounced your last name properly, Stuart.
You did.
All right, excellent. So before we get started, kind of wanted to tell folks kind of where we are and what we're hoping to hear a little bit from Stuart this morning. We've had quite a bit of pushback related to the sections involving the forensic facility for folks who are developmentally disabled and the Commissioner of Dale oversees. And we are frankly, at this point, considering and leaning towards, frankly, because of timing issues as much as anything, of taking out the forensic facility component related to Dale. And certainly can hear a little bit more from Stuart on that, but I think we've heard quite a bit of testimony on that already. And it's, again, it's a matter of timing. It's a matter of the input that we've received from the disability rights community, from the Disability Law Project. And not to say that the forensic facility isn't appropriate, and I think we've heard very good testimony that it is. However, I think that it needs more time. I think it needs more time to make sure we get the process right. I think the process might be a little bit different for that community. And we want, I'm planning on writing in or proposing in the next version of this bill some form of a task force, I'll call it, that's much narrower than the 29 or 39 or however many people were looking at the forensic facility last time, having it much narrower to just the disability, developmentally disabled component of this. So that's where we're leaning. You certainly can take your time to try to convince us otherwise, Stuart, but I was hoping more so that we received, and it's on our webpage, some pretty in-depth written testimony from Rachel Seelig of the Disability Law Project, also pointing out some issues with some other provisions not related to the forensic facility that we are trying to fix in essentially the Act 248 process. And so I asked Stuart, I emailed him last night to see if he could particularly address those components, but you're welcome to open as far as, on anything else that you may want to bring up this morning. We may have other questions as well. So please proceed. Identify yourself for the record and proceed.
Certainly. Thank you, Mr. Chair and members of the committee. My name again is Stuart Schurer. I'm the General Counsel for the Department of Disabilities, Aging and Independent Living, also known as DALE. I will proceed with my comments this morning with respect to both the forensic facility and the specific components of the Act 248 process, and I'll leave it to the committee to decide how it wishes to proceed with that information. So Dale has reviewed draft 2.3 and with one exception supports the draft as written. So I want to address that today, as well as respond to a few points raised in the written comments provided by Rachel Seelig of Vermont Legal Aid's Disability Law Project. And I will submit those written comments to the committee this morning. I did just have an opportunity this morning to look at those written comments from Ms. Seelig. But first, the first concern we have with respect to draft 2.3 is on page 28, and that's lines 3 through 8. And that has to do with the administrative discharge hearing and the notice of that hearing. And so while the amended language makes it clear that the state's attorney or the attorney general and the victim may request a hearing on the pending administrative discharge from the forensic facility, and that hearing shall be held within 10 days after the state's attorney or the attorney general or the victim's request, it's silent as to how long after receiving notice of the pending administrative discharge the state's attorney or the attorney general and the victim have to request that hearing. But more importantly, the proposed language stays the commissioner's administrative discharge from the forensic facility until the matter is reviewed by the court. But if the court begins its review but then continues the hearing for days or even weeks, the discharge would be stayed and the individual would need to remain in the forensic facility, which may not constitute the least restrictive setting for that individual. So for that reason, Dale proposes the following, and I again will send this to the committee in writing. But looking at subsection 2, if entitled to appear and call witnesses in the underlying criminal case, the state's attorney or the Office of Attorney General or the victim or both may, after receiving notice, we would insert that, request a hearing on the person's pending administrative discharge from a forensic facility, which shall be held in the Family Division of the Superior Court within 10 days after the commissioner's notice of discharge to the committing court and the state's attorney or the Office of Attorney General. Discharge shall not occur within the 10-day period following the commissioner's notice. So we believe that that would address the concerns about the timing and would ensure that a delay in the conclusion of the proceedings wouldn't delay the ability to discharge somebody from the forensic facility if it were no longer deemed the least restrictive setting. But in the alternative, there could be clear language setting a time frame by which the court order must be issued once the hearing is commenced. That would be another way to address the situation.
So with respect, just before you move on,
Sure.
for that particular section, and actually similar language, I think on page 12, related to the DMH side of the equation. Currently, I think I have the language we have in here. I have some language I received from the state's attorneys, and now I have the language from you. And probably the best way to try to hash that out, if in fact we're keeping this in here at all, is for a discussion, probably state's attorney and you, Stuart, and probably Karen, Barber, and maybe get legislative counsel or somebody from here, maybe Joe or I, to kind of finalize that, since we have like 3 things floating, and rather than trying to sort it out right now and here, that would probably be a better way to try to sort that one out. And the same goes for that language that's, I believe it's on page 11 or 12. So proceed with that, and we can figure that part out afterwards.
Sure, I appreciate that. And DMH and Dale have communicated with one another, and we believe that these sections should be aligned because we have the similar concerns about the discharge timing. But we certainly will work together and work with Jared and others at the state's attorneys to try to get you a consistent proposal.
Yeah, and just timing wise, if we could figure out how to work that today, tomorrow morning, because we're going to be working on a new draft. Really at noon is when I'm meeting with given the input that I'm getting from the committee, going to be meeting with legislative counsel. So if we can get something by the end of the day, that would be best.
Sure.
All right, thank you.
Thank you. So let me turn next to Ms. Selig's comments. But first, I want to say that I'm frankly a bit disappointed that we're now only hearing from the Disability Law Project about not only the concerns with the proposed forensic facility, but more specifically, the proposed changes to the Act 248 process. Ms. Selig did note in her testimony that she had not been aware of the bill until Mr. McCullough brought it to her attention. However, Dale had alerted the Disability Law Project to the proposed changes to the Act 248 process long before this session started. So I just wanted to state that at first. But that said, Dale asserts that there is a need for a non-community-based programming option for a small group of individuals with intellectual disability who present too great a risk of harm to the community. And frankly, we disagree with Ms. Selig's argument that such a placement would necessarily violate Olmstead and the integration mandate of the Americans with Disabilities Act. Ms. Selig's comments fail to recognize that often community-based services cannot be reasonably accommodated, taking into account Dale's available resources. But let me move specifically to 3 areas that are raised in Ms. Selig's memo. One is the definition of a person in need of continued custody care and habilitation, which you'll find on page 22, lines 17 through 20, and continuing on to page 23, lines 1 through 4. The Disability Law Project opposes the expansion of the danger of harm criteria when in subsequent annual reviews, the court needs to determine whether to continue the individual's Act 248 custody. The proposed definition of a person in need of continued custody care and habilitation, however, includes text that is taken from the existing definition of a person in need of treatment, which you can find in Title 18 VSA Section 7101, paragraph 17. That's in the mental health context. And it reflects the longstanding practice in Act 248 judicial review proceedings as to how the family division assesses the individual's need for continued Act 248 custody. And in assessing the need for that continued Act 248 custody, the court would and currently does assess the weight to be given any behavior exhibited or conducted committed since the last annual review. So that is Dale's response to the Disability Law Project's opposition to the expansion of the danger of harm criteria. Any questions on that?
Barbara.
So I probably have more than one question. I need to digest the Act 248 custody part, but in the first part, when you said that you disagree that it violates Olmstead, taking into account Dale's available resources, I'm assuming Dale's available resources is a key factor, right? Like if Dale had more resources, it might be able to do something else. But given the resources, this is what Dale can do.
Yes, when we're talking about financial resources, all those resources, certainly.
So I know that this isn't our committee's jurisdiction, but I know that the cost, it would be nice to have sort of the data to look at what does it cost to build and serve somebody in the forensic center, and what would the cost be to provide what Rachel Seelig's sort of alternative was of serving them in a different way, because I don't have that information, and it just would be helpful to have that.
Certainly, I appreciate that. And I did note Ms. Seelig's financial figures that she put in her footnote. What that footnote fails to acknowledge, however, is that we're not simply talking about people who are on receiving public safety funding. Oftentimes, and increasingly, the department is working to adequately provide programming to individuals in community-based settings who present such a danger of harm that the department has been unable at times to find staff within its partners agencies to support those individuals. As a result, there's been a need, as required by the court, in providing that custody to those individuals and care and habilitation, to look at outside resources, human resources, to fund those supports. And oftentimes you can imagine contracted supports with outside entities is far more expensive than working with our designated agency system or our specialized service agencies in providing those services. But when those agencies can't provide staffing because no one wants to work with individuals who are of such a danger and who assault those staff members, oftentimes those agencies and or the department are required to go outside its designated services network and pay a much higher price. So we are looking at potentially 5 to 10-fold increases in budgets in paying for individuals with services outside of our designated agency system. And so it's hard to pinpoint exactly what that cost would be, but we have anecdotal evidence and specific instances where individuals are costing an exorbitant amount of money to serve in a community-based setting. And I would venture to say that those costs would be greatly reduced, frankly, if there were a forensic facility that could accommodate and provide adequate programming to those individuals.
Stuart, can you give us a sense of how many individuals we're talking about a year?
Individuals who are in Act 248 or who would present such a danger of harm that would be potentially eligible for a forensic facility.
The latter.
The latter. I think it would be a handful, if that, maybe 1, 2, or 3 at most.
So
we do know now, for example, that there is someone who would greatly benefit, probably from being placed in a forensic facility as opposed to being remaining in an incarcerative setting, where they're awaiting a new competency evaluation. So that is certainly one reason for the need for the forensic facility. But that is perhaps one individual, but I imagine there would be very few who would be placed or recommended for placement in a forensic facility with intellectual disabilities on an annual basis.
and yet we would need to staff that facility, right? Like there's no, I'm concerned about what the fixed costs are to keep that facility going.
Sure, and I think that I don't think that there would be any vacancies necessarily in the forensic facility. If this were used for both intellectual disability and for those with mental illness who present a danger of harm, I do believe that the staffing would be there and would be available and would be utilized. But as far as how many individuals with intellectual disability would be in those beds, I would venture to say that it would be no more than 3 or 4. So
just one comment on your comment about the designated agencies, and I had the privilege of working in one of the designated agencies for 3 years, is I know that even with what the legislature has been able to do in terms of providing increases, the designated agencies are still, in many cases, precariously funded, and the salaries they're able to offer still are sometimes, I mean, I know staff sometimes are like, I can make more as the Hannaford's manager, and nobody's, it's an easier job. So when we talk about contracting with someone else and paying more, it's one of those tricky things of like, well, that's really sort of fair market value, but the designated agencies are kind of stuck in another funding system. So I just kind of want to put that out because I think that's really important at looking at what would it take to adequately fund our continuum of mental health community needs, and saying that as much for the committee as for you, because I do really think that's key. So thanks.
yes, thank you for that. I agree that is a barrier currently, and it's one of the reasons that those resources are not available. We have individuals who do present a serious risk of harm to not only the community, but to their staff that are working with them. And so you can imagine that staff may be reluctant to remain at a job where they're being assaulted on a daily basis. And so that adds to the labor challenges that the agencies are facing. But because there is a court order that commits an individual to the custody of the Dale Commissioner, the Dale Commissioner is required, as long as that order remains in place, to find a placement for that individual. And so that is the struggle that we're currently dealing with.
I appreciate that. Thanks.
All right. So before I go to Ken, who had his hand raised, so just how we're proceeding with this, we are certainly not the Act 248 committee. But I was hoping to, at least get some input relevant to what we heard from the Disability Law Project, and see if we were able to figure that out in a straightforward manner in here. But it looks like it's probably not going to happen because their position is that that this would make it harder to discharge from Act 248 than it is to be committed pursuant to Act 248. And you could explain that away, and that's just not us to know that. So we can continue and also get your input on those other couple things that Ms. Seelig said. But almost certainly, I'm going to be talking to the chair of Human Services and ask them to take a look at this. Hopefully, short of sending it to them for their possession, just timing wise, that would take a bit of effort. But just have them be able to do a drive-by. It'll be an intensive drive-by. But just so folks know, I'm not expecting that we're going to resolve that particular dispute. So in any event, if you could proceed with the other points, though. Ken, did you have a question first?
Yes, thank you. Do you know how many murders we have a year in Vermont?
How many murders we have a year? No,
Yeah.
I do not.
Would you like to answer that? Can you answer that?
Yeah, identify yourself for the record.
I'm Matt Valerio, Defender General. We average about 12.
12. Thank you.
We're a little higher the last year or so, but the average is about 12.
Thank you. Do you know, back to you, Stuart, do you know how many of these, or how many domestic violence cases we have dealing with this that are mental health related?
I do not.
Can I ask Mr. Valerio if he does?
Sure.
I don't know how many are mental health related.
Yep.
You good?
Yep.
All right. Joe, go ahead.
If you're going to get this, I'm sorry, Stuart. But one of the questions I wanted to ask you was one of the things that we have been trying to figure out is with an understanding that the purpose of the forensic facility is for those who have either been found to be presently incompetent to stand trial or found not guilty by reason of insanity. One of the things we have been struggling with is the fact that the forensic facility permits a much more restrictive level of care with regards to restrictive means, the use of forced medication and things like that would be available in residential facilities and other facilities around the state. I'm not exactly sure how that applies to community placements with regards to Dale. This has been a DMH thing. So I guess part one of my question is the level of care at the forensic facility something that could not be provided to folks under the care and custody of the commissioner than other places in the state? And I may have a follow-up question depending on your answer.
Sure. Well, certainly an individual has what's called an individualized support agreement, and also what's called a behavioral support plan. The behavioral support plan could include certain conditions under which the individual could be restrained, even in a community-based setting. So there are circumstances under which, if the proposed behavioral support plan is approved by the Human Rights Committee, then it would be then the individual could be subject to some of those restrictions that would be available in the forensic facility as well.
Okay. So here's the reason for my question is I'm not sure whether that fully answered it or not, is at least on the mental health side of things, one of the concerns that I've at least had is the fact that these restrictive means, forced medication, are things that can't happen in the residential setting, but could happen in the forensic setting. And the only difference being that this person who may be going to the forensic setting is accused of committing a crime. However, they've not been adjudged to have committed a crime. So one of the ideas we were throwing about was the idea that, and this language we found on page 19 of draft 2.3, in particular line 16 through 19, the idea that there has to be a finding that the person is presently incompetent to stand trial or has been found not guilty by reason of insanity, and that the evidence that the person committed the alleged crime is great, which is language we took from the bail statute. And I was just wondering your thoughts on that, if it was a good idea, bad idea, or I don't think it's one way or the other about it.
I'm sort of agnostic on the issue of, I mean, I think that that's a reasonable standard to use, that there is evidence that the person committed the crime is the alleged crime is great. I do share some concerns about the availability of medications and forced medications on individuals with intellectual disabilities, and perhaps there is a way to distinguish between those populations. I can't speak to whether that would be appropriate under what circumstances that may even be appropriate to administer to someone with an intellectual disability. So maybe that is something that could be carved out or distinguished between the population with mental illness versus the population with intellectual disability. But that being said, I do think that it's reasonable that before there is a commitment to a forensic facility, that there should be evidence that the alleged crime was committed is great.
Great, thank you.
Mm-hmm.
All right, if you could proceed with.
Sure. So the next point that Ms. Seelig raised regards the provision concerning commitment at page 25, line 9. And Ms. Seelig asserts that the responsibility for filing an annual review should lie with the commissioner, while leaving in place the right of the individual to seek a review 90 days after the order is issued. While this section gives the person a right to request an annual judicial review, the responsibility for requesting the annual review does in fact lie exclusively with the commissioner. That's the current law. So I'm not sure I understand where the objection is here. But Ms. Seelig then asserts that the Disability Law Project should be notified that upon initial commitment, and that current practice is to first notify the Disability Law Project at the first annual review. But as we know, in accordance with 13 VSA section 4820, when a person is found incompetent to stand trial, has not been indicted by reason of insanity, or has been acquitted by reason of insanity, the person shall be entitled to have counsel appointed from Vermont Legal Aid to represent the person. So I'm not clear why there's a concern here about not getting notice until the first annual review, when it's clear that the Disability Law Project does receive notice and participates in the original commitment proceeding. Maybe I'm missing something there.
And could you remind me of where, looking at draft number 2.3, that concern came up?
Yes, I think we would look at page 25, line 9, okay, which is where the commitment process would start.
Gotcha. Thank you.
Sure. And then my final comment would be with respect to the provision regarding administrative discharge at page 27, starting at line 13. And Ms. Seelig, with respect to that provision, states that the Disability Law Project could support an administrative discharge from Act 248, regardless of placement, provided there's no notice given to the state's attorney, the Attorney General's office, or the victim. Under the current procedures outlined in 13 VSA section 4822 and 4823, the state's attorney or the Attorney General's office is a party to the original commitment proceedings, and they are required to provide notice of the action to the victim. Given that the state's attorney and the Attorney General's office, their interest in the particular matter, as well as ongoing interest in the protection of the public, it makes sense to Dale that the state's attorney or the Attorney General's office be given notice of the proposed discharge and an opportunity to inform the family court of any concerns it may have with the proposed discharge. Again, the family division will determine the weight to be afforded to any testimony provided at the discharge hearing. And with respect to annual reviews, the language added to section 8845B3, which is on page 27, lines 1 and 2, that would authorize the court to exclude persons not necessary for the conduct of the hearing. So those are the comments that I have as to Ms. Seelig's testimony, and I'm happy to answer any other questions you have.
So any other questions at this point? So it sounds like the way forward on this is that, you know, we are going to, I'm going to have a discussion with the chair of Human Services, see when they can take up some of this, because like I say, some of these are really their policy decisions more than ours. And we'll try to get feedback from them before the next version. So we will be taking more testimony on whatever version we have tomorrow. We will be taking more testimony on Tuesday, probably of next week, with the hopes of soon thereafter trying to vote this out either Tuesday or Wednesday of next week. So you should expect to hear from us for setting you up to provide any final comments on Tuesday. So I appreciate it. No other questions? We will let's move on to Jared next.
Thank you.
And I think the area that we want to talk most about perhaps this morning, unless you have other things to comment on, is the language that we continue to grapple with on page 11 and 12. We'll put aside the language that's in the Dale component, because if we figure it out here, we should be able to figure it out there. So do you want to set this up, Joe, as far as, because you've been working and looking at this a little bit?
Sure, I'd be happy to. Let me just pull that up and flip to the proper page. There we go. Cool. So looking at draft 2.3, looking at section 7, which is the order of non-hospitalization. So my concerns here have to do with sort of the logical flowing of this section and making sure that it's clear to folks what's going on, so that someone can look at this and understand what the process is here. So sort of my first piece of concern is that, you know, this section is entitled Order of Non-Hospitalization. If we look at the language that presently exists in this section, it really is pretty narrowly tailored to have to do with the order and what the order is all about. And in the new language that we've been adding as we've been working through this bill, we've added in additional things, particularly about how the discharge occurs. And I noticed that there's really two discharge procedures that are mentioned in the section. So if we look at page 11, starting on lines 7 and 8, it mentions the idea that there is a court review possible. So the court may at any time on its own motion or motion of an interested party review the need for treatment at the forensic facility. And this sort of stops there and doesn't talk very much about what's going, you know, like what that procedure might look like. And then it talks about this commissioner discharge procedure. The idea that, you know, when the person is committed under the subdivision, shall provide at least 10 days notice, and then talks about the state's attorney and the victims getting notification, and then goes on, as you can see, to talk about, you know, how many days and all this stuff. And it occurred to me that this ends up being confusing, at least to me, because I feel like we're commingling what this order is about with a procedure with regards to how one is discharged from the forensic facility. And I'm wondering your thoughts both about the content of those procedures that's outlined in the yellow and green highlighted text we have here, and your thoughts about, is there a better place to put this in the statute that just might be clearer that this is discharge procedures and actually doesn't have very much to do with the order itself?
I think that's a really great point. That may make sense. I would really want to consult with our partners who are, you know, chiefly responsible for the Title 18 process before sort of opining, sort of off the cuff, because these are not we have an interest in the process with respect to the folks who come in via Title 13, but we don't want to be, you know, the Stuart and Karen and those folks would be in a better position to advise about the general structure legally. So I understand what you're saying about the structure here, but I would certainly want to consult with the Human Services folks before sort of suggesting changes to the underlying meat of the O&H process, if that makes sense.
Yeah, yeah, and it is, I guess of course, the meat of it matters, but I don't think we're trying to change the process. And if my understanding is correctly, the yellow highlighted language came from DMH. Am I correct about that?
Yeah, DMH, state's attorneys, and right. Yeah.
So, they sort of suggested at least the yellow highlighted language. The green was stuff that we were trying to work with. But I guess, do you think, if you're not comfortable in commenting on the procedural aspects of it, are you able to comment at all, just sort of, is there a better place for this to go? Or is there just a better way to make this more logical for folks so they can understand what's going on if they are involved in one of these proceedings?
So what I can say is we think that the language as it's set forth, I'll talk more specifically about some of the highlighted language, but the language as set forth here, it is a language that we came up with together with our other stakeholder folks at Human Services and the administration. We think that it remains appropriate. I do think the crunch of time in the legislative process sometimes makes it difficult to find the best solution with respect to structuring these statutes. But I read this as having a logical flow to it already, in that here there is basically additional opportunities. If you're looking at, I think, page 11, line 7, additional opportunities and protections for review, but then there's a specific structure for the discharge in those following highlighted sections. And if I can, I wanted to come back to a question somebody had earlier for Stuart about the evidence of the crime being great.
That's right. There's going to be the next question, so that's a great segue.
I think that's completely acceptable. It's consistent with what we do all the time in other kinds of hearings. It is also something, Act 248 is distinct from the DMH population. Act 248 already has some degree of showing of culpability built into it. So this is not an undue burden, and it would make logical sense from the state's perspective. So I do think that makes sense. And I just want to say, I really think that Stuart hit the nail on the head. I've worked with Stuart quite a bit, and as usual, he's really, I think, gotten to the nut of the issue. I worked with Stuart when I was a assistant attorney general representing Dale, and I was responsible for the Act 248 docket. And I agree with him that Olmsted is not offended by what we're discussing here. I won't get into sort of the in-depth Olmsted analysis, but suffice it to say that this does not offend Olmsted from my perspective. And what we're really talking about here are situations where people are in the community who aren't safe for other people, but also themselves. And that results to repeated serious injuries to staff. And it results in increased calls to law enforcement. And I think you've probably all heard plenty about the difficulties that can arise when there are increased, unpredictable mental health related calls, and law enforcement is left to deal with that. That can result in new charges or incarceration for the person, or physical interactions that could be dangerous for both law enforcement and the person. And what we're talking about here is the safer, more secure solution. With respect to some of this discharge language, agree with Stuart that we don't want a logjam, but we do want to make sure that we're not providing a hearing process here for something that doesn't matter. And I think if we were to do away with the stay until the judge hears the hearing, then you're providing a hearing right that has no substance to it. However, we would agree with Stuart that additional deadlines, for instance, deadlines to file the request, deadlines for issuing the decision on the discharge, all of those make sense from our perspectives to protecting the rights of the people that will be the subject of these hearings, to make sure that the agencies have the ability to manage and have predictability with respect to what's going on at the facility, and to getting clarity and finality on these decisions. So we would support having deadlines, even tight ones, and clarity. We would just not want to do away with the stay without having that judge imprimatur. So otherwise, I would associate my comments with what Stuart said. Would note one minor change that actually nobody has brought up, and it's my fault for catching it earlier. But on page 20, I believe line 20. Sorry, I'm just scrolling. Sorry, page 20, line 16. It begins by excising cross-reference to 4822. We would urge the committee not to excise that application of 4822, at very least going up to the end of the word section on 17. We think that the application of 4822 is appropriate in these cases. Just to remind you, 4822, what it's referring to there is a different provision regarding discharge hearings for cases involving injury, and we think that that remains appropriate. It's something that does apply to DMH and would apply and does apply to Dale currently, and we think within the context of this bill, removing that particular cross-reference may not be working toward the ends that we're trying to accomplish with this bill, which is, greater transparency. So I'm sorry, I sort of took off on some comments, and I realized that you may have had more questions. I apologize.
I have a question as well, and we can get back to Joe if he has additional ones where he was looking at. So we are considering, because of some, I'll call them headwinds or pushback or concerns, of moving, of taking out section 2 and 3 and putting that back into the rulemaking. Not so much because of the criteria that would be considered in that rulemaking, but more so the process that is anticipated being considered in the rulemaking that is struck at page 29 to 30. And I'm looking specifically at page 29, line 13, where it talks about the fact that it's the process used by the commissioners to determine appropriate admissions. And we haven't, the process is laid out certainly in the section 2 and 3, but I think so far the feeling has been that that needs to be fleshed out a little bit more, or just needs more input, and we haven't heard about other alternatives, et cetera. So I just wanted your comment on that.
We think to do away with those sections would be to really take a pretty substantial step back with respect to where this bill is and where it's been. We believe that the structure put in place in the statute here obviates the need for that rulemaking, because those criteria are clear, and everyone would have an opportunity under those criteria to talk about whether or not those criteria are met in a given case. The rulemaking process would, in our estimation, be an undue delay to being able to utilize this important tool. And I think you heard some powerful testimony from the victims about, why we can't just continue to kick the can down the road. Rulemaking is important, but in a situation here where the legislature would be providing clear guidance with respect to what the criteria are, we would be able to implement this much more quickly and address this gap in a much more prompt fashion. So, from my experience, rulemaking can take, it could take a year, it could take more, it depends. And not having a solution in place during that time period, when we've identified what we believe to be the appropriate standards and the appropriate process already, would be unfortunate.
So, but the effective date is not until July of 2024 anyway. So the effective date for doing the rulemaking would be upon passage. So I think this was already contemplated, having some time, and we haven't had anybody starting to talk about changing that effective date, even with the taking the rulemaking out, because I'm sure there are other things that need to happen between now and actually using the forensic facility. Certainly I'm hearing that from our Corrections and Institutions Committee regarding the actual space and such. So So the timing part, I'm a little less concerned about. It's the process and having had sufficient input on what this process is for the commitment to a forensic facility. And I don't know that we've had enough time in the context of this committee to make sure that we've fully vetting that process that's set forth in section 2 and 3. And we've certainly heard some concerns about it.
I think that's fully within, Mr. Chair, the ability of the committee to make that decision, and I respect that. I would just say that this is a process that began really with conversations arising out of the Forensic Study Committee that's gone on for quite some time beforehand. And so when we came to this discussion in the legislative process, it was after having been involved in that process as directed by the legislature previously, and pretty well informed with respect to what these criteria would look like. But of course, if the committee feels that that's the best path forward, then that is your prerogative.
I appreciate that. Other questions for Jared? Joe.
Just want to follow up a little bit more on the page 11 and 12 language. What, as you can see in draft 2.3, there's both green highlighted language and yellow highlighted language. And the green highlighted language was an attempt to integrate, someone had mentioned, unfortunately, I don't remember who, that the yellow highlighted language was based on 13 VSA 4822. And this was sort of an attempt to integrate some of the elements of 4822 into this section. I was wondering if you could just comment on the green highlighted language.
And I'm sorry, could you just point me to a page again? I apologize.
Oh, I'm sorry. It's page 11 and 12. Both have the green highlighted language on it. We already spoke about the evidence is great. So not that aspect, but the bottom of page 11 and onto page 12.
So, and before, just real quickly on that as well. So that section C is what I mentioned with respect to when Stuart was testifying, that we have our language here. I've received a suggestion from the state's attorney, and I've received a suggestion from DMH, and we need to kind of get those three together. But go ahead and comment anyway, but understanding that we're asking you to hopefully work later today on reconciling those three different, slightly different.
I think that will be an entirely doable aim. I think that as set forth here in 2.3, this is good language. We appreciate that the stay would be in place until the court issues a decision. We also would be amenable to the deadline structure referred to by Attorney Scher. So I think this is a strong starting point. There are maybe some minor edits that it sounds like we'd be able to get together and offer. But I do think that there is sufficient sort of baseline criteria here for us to work with, and maybe just get some preferences or clarity in place amongst us and get it back to you.
Thank you. All right, any other questions for Jared? Not seeing any. I'd like to, if Matt could join us, and I had a couple questions and certainly wanted to get his input after having heard additional testimony, but.
I don't know if I need do I need the?
Good question. I'm not sure.
Well, I don't have anything in there that's not in my head, so.
All right, fair enough.
I'll bring it. But it is because you never know.
You never know. So I guess I wanted your comment, given some testimony we received yesterday from Karen Barber talking about the process set forth in Section 3, and you had a couple concerns, well, about Section 2 and 3, and you had voiced a couple concerns that she had responded to. And I think I'll summarize, and somebody else can tell me if I haven't gotten it quite right from what Karen said, but essentially the concern about the members of the panel and the influence they have, that ultimately the process has to go through a court anyway, and it's the court that is making the decision. And the defender and the attorneys do have the opportunity to be heard on what the recommendation is as far as the placement to a forensic facility. And I don't know if you heard that testimony or if you could just comment on that general.
I didn't see the testimony.
Yeah. So,
I mean, if on the one hand, they want the panel, on the other hand, they say, oh, don't worry about the panel. And the people on the panel are the ones making the decision. Part of them are the people making the decision about whether to commit to a forensic facility, including the Commissioner of Mental Health, who is on the panel to decide that is making a recommendation as to what the Commissioner of Mental Health is going to do. It doesn't make much sense to me. See, this maybe I'm too simple. It's quite possible. But the whole thing about a forensic facility is in 2011, we had effectively a forensic facility. We had the Vermont State Hospital that was available to us. It got washed away in Irene, right? We had processes for people to be there and not be there, people to go in and to go out. It was all governed by statute at the time. The problem is, since 2011 to now, we haven't had that facility. I believe we need a facility. The processes are still in place. The issue is not about creating new processes. The issue is about using existing law to put people in a place that used to exist, that doesn't exist now, that we hope will exist on some level going forward. All a forensic facility is a higher level of placement. And that placement can be argued and discussed under current law. And I don't think that there's a lot of law that needs to be changed. What really needs to be changed is we need a facility. And so I don't know if this committee doesn't add anything, then why do you need it? I don't understand how that is going to change the law as it stands unless you change the law. So there's the review of this by our appellate division, as I said yesterday, was this looked akin to a civil commitment panel, which typically has experts who evaluate based upon medical, psychological, scientific criteria. And this, to me, looks like a political panel. And that was what the evaluation of our appellate division was as well. So, that's the response. You can make a choice and do what you want to do. I don't know how giving this group the ability to review when the Commissioner of Mental Health works for the Secretary of the Agency of Human Services, the Commissioner of Disabilities, Aging, and Independent Living works for the Secretary of Human Services. The Commissioner of Corrections works for the agency of the Secretary of the Agency of Human Services. How that, what is the assistance there, except for maybe your boss is telling you, no, we want this person in a forensic facility.
Right. So let me parse this out a little bit, and then we'll go to Joe. So we have, Section 2 is setting that up. If that was a differently constructed panel, does then the process that's in Section 3 give you as much concern, or I'm trying to separate those two things out. So we have the makeup of this panel. Would there be a recommendation as far as a better panel to be making this recommendation?
Well, if you were going to have an actual civil commitment type panel, you usually make it up of psychologists, psychiatrists, medical doctors, perhaps an attorney, perhaps a public member, perhaps a member of law enforcement or Department of Corrections, or somebody like that is appointed and independent. Do we really need that? I mean, we didn't need it for decades before 2011. The fact that we're bringing back a forensic facility, does that put us in a position where we now need it? Now, I don't, in our office doesn't deal with the Title 18 after the finding of competence or sanity. We used to, and I've done those, as you come in through the Title 13, I've done those before. But to me, if there's judicial review and there's clear criteria, I don't know what the panel adds, except for the fact that you would be doing if the panel had ultimate decision-making authority, then you would have an ability to challenge that in Superior Court. To me, the law is already there that supports what a forensic facility needs to do. What we need is the facility.
So one more question, Joan. Sorry, Joan.
And I don't know if I'm directly answering your question.
No, I think so. No, I think so. No, I'm trying. I mean, so with the psychologists and doctors and all that, even under this, they would presumably be in front of the court for the commitment hearing of where the person's going to be sent.
Right.
And then what they would have as far as the recommendation could almost be looked at as it's a recommendation of the administration that has all the beds and such of where we think we should put that person in the secure residential, in the hospitalization, or in the forensic facility. So it's just the recommendation of the space, and given the individuals that they have to move around, and it's presented to the court, and that's where the arguments come out with the psychologists, doctors, experts, etc.
Wouldn't they do the same thing? I mean, I'm guessing, what's the point? What's the point of the panel? I have a guess of what the point is. If there's a disagreement with what the medical folks say ought to happen with this person, you'll have a political panel that will say, we want them in a forensic facility as opposed to a lesser level of treatment. And that's to put political rather than medical and scientific pressure on the court to do something. But I trust in general that the court will see through that and make a decision based upon, the science. But we're at a point now where you've got to make a decision about whether that is appropriate or not.
I appreciate Joe, and then Barbara.
So, so yesterday, Karen Barber said that the purpose of the panel, from their perspective, was to basically make transparent something which is already occurring, which is a political appointee. The commissioner talks to people within the department to try to make a decision of sort of what recommendations to be made. And I can certainly see your concern about that it is political appointees on the panel. At the same time, a political appointee makes the decision if they're going to recommend forensic facility. And so, I guess I wonder what your response is to Karen Barber's assertion that the purpose of this panel is to make transparent that which is already occurring, which is consultation with colleagues about should I go in this direction with this person or that direction before making the actual decision to make the recommendation to go in the forensic facility.
If you remember my testimony previously, I had talked about the fact that we don't feel that there's an issue with notification of prosecutors, notification of victims regarding what is going on, something that isn't going on right now. And I know there is some concern about that by some of the advocacy groups. We don't have an objection to even input, and the court can take that for what it's worth. We don't have a problem with the judicial review of the decision making, which would be public. So I think the transparency is provided by doing other things. I don't know that you add much in the way of transparency by creating the panel. I mean, I don't know that anybody would even know, frankly, that the panel exists aside from, the people in this room and, 20 other people in the state who deal with it.
And my other question, you said a few times a moment ago that you believe that processes already exist to admit someone to a forensic facility. You're just referring to like, Chapter 181.
Right.
And so,
Because that's what we used to do when we had a facility that was, when we had the state hospital. That's what we used to do.
so you don't think outside the actual creation of the facility of language that we need any of this other stuff that's going on in this bill?
I think fundamentally you don't. I mean, the added pieces here are to satisfy victims and public's interest in transparency, to satisfy defendants' right to judicial review of decisions made, and the like. But I think that the statute existed before, and we used to use it to commit people to the state hospital when we had one. And, we used to get people in and out quickly for evaluations. We're in a different time now because of backlogs and that sort of thing. But the fundamental structure and ability to make that decision is still there, and it has been in statute for years.
Thank you.
So, it's anything can be tinkered with. I mean, we can look at any statute and say, oh, we might make this a little better. I think some of these things, for the people who are interested, and, we heard the victims themselves come and testify yesterday, I believe, and, they have concerns that were not addressed when the statute was originally, it was a different time then when it was originally drafted, and those can be incorporated in here without really fundamentally changing what's going on. See, so the issue of like this rulemaking versus putting it in statute that is going back and forth, I think that process already exists. So I don't understand the reticence about that. We've committed people in the past, necessary, and I've in my testimony the parts of the cases I can discuss that have been public. I've named some names, all of whom have been in the mental health system for years and years, and who have been violent and dangerous and the like, and they remain in the mental health system. And so we can do that when we decide we're going to do it, number one. And number two, when we have the capacity to house them, and what we really need is that capacity.
Thanks.
Go ahead, Barbara.
So Matt, I appreciate you putting sort of the issues in a simple manner for us. The part where I'm struggling and sort of went back to check my reality are when we had an institution, yes, people could get evaluated, but it was problematic. And I'm looking now at a letter to Governor Douglas in 2005 about the investigation into the troubles with the state hospital, including protecting people from harm, restraint and seclusion, inadequate psychiatric and psychological services, inadequate integrated services. So
That sound at all familiar?
It does sound very, very familiar.
Department of Corrections?
Yes, it does. Yes.
Well, these are things with big institutions where we seek to lock people up
Yes.
that are inherent. We have to daily fight that fight.
So what can we embed in order to minimize the chances of creating the same issue? I mean,
See, a lot of these things, you aren't going to cure all problems,
no, I know, but I don't want to be part of creating a big problem.
A lot of the issues, and my office investigates, like, for example, the Department of Corrections issues.
The deaths and yeah.
Deaths and any serious incident when somebody's in the custody of the Commissioner of Corrections. So attempted suicides. We also do conditions of confinement issues regarding access to medical care, psychiatric care, adequate food, all kinds of things, right? And a lot of these things, frankly, boil down to individual decisions being made at the time by individuals. The question is who's checking the individuals, right? And it has to do with these decisions are good decisions and bad ones are going to be made by individuals all the time. Vast majority of them are good decisions, but there are bad decisions that also happen not all the time, but regularly. All right. Where's the oversight? That is going to be that's the biggest issue. And we do have groups, Disability Rights, Defender General's Office, Legal Aid, and others whose job it is to provide that oversight. And it is not, sometimes it's people who are groups that are just outside of government. Sometimes they're part of government. But it doesn't obviate the need to have the institution. I think it goes to a different question, which is how do we oversee to make sure that there aren't abuses? And I think that's probably a little bit beyond the scope of this, but know that there are organizations out there that's their job, and advocacy groups as well that are not the Defender General's Office or Disability Rights or Legal Aid. That are also trying to keep watch on this, and we aren't perfect about getting it, but we do what we can with the resources we have.
So does that speak further to the panel being made up of just state government in terms of like checks and balances?
I mean, that's kind of the concern, and I get a sense maybe that the panel is looking at, checking decisions of, doctors or maybe even internally about decisions that are made that they don't like, that don't, and notice that it's a public safety panel. That's the title of it. And it is, I don't know what it adds that isn't already there. Maybe it is more a matter of, I really don't know what it adds. I mean, I don't know what it adds.
So, did you have any, those are the main things I kind of wanted to talk a little bit more about that section. Are there other points that you wanted to make at this point?
No, not really. I feel like I'm coming back and kind of just reiterating what I've been saying right along. But I try to boil this down to, what's the fundamental need? Fundamental need is for a facility, I believe. And I think that a good case has been made for more transparency for victims and for judicial review, open judicial review of the decisions that are made. And those are like the three main things for me.
And for us too, but we're working around the edges as well.
I understand.
Yeah. Appreciate it. No other questions. We'll turn to Judge Zone.
Morning.
Good morning. Thank you for being here.
My pleasure. Tom Zone, Chief Superior Judge. I haven't previously weighed in on this bill either in the Senate or in your committee. So I have focused on what I understood to be the area of inquiry for myself, and that was Section 7, where we talk about the order of non-hospitalization. And when I looked at that, and I've heard the testimony today, I have to say the first word that came to my mind, and I apologize, was confusing, because it seemed to bring a lot together into one section. And on the one hand, it's, well, here's how the order gets issued. On the other hand, it starts talking about discharge. And so I think the first comment I would have is I would suggest considering, and I know it's late in the process, but breaking these apart. Have the one section for the order, and then have a separate section, whether you call it 7618 small a, no parenthesis, or somewhere else to deal with the discharge.
Apparently you and Joe were talking already about this. So I think that we've...
When I was listening to the testimony, I was writing that down, and I believe Representative Adriano actually was thinking that too. And I thought, okay, I'm either great minds think alike or he should be nervous. I don't know which one. But I think that would be a step to add clarity. When we look at this bill, what strikes me is that it's important to keep in mind that this section applies for individuals who come into the mental health system through the criminal side of things, whether it's an incompetency or insanity under section 4822 of Title 13, or whether they come in under the civil commitment side. And so it brings the two of those together. And when I look at on page 11, what's the green language about evidence of guilt and incompetence, that language, I don't know that that language is necessary here, because whether or not an individual has that qualifying information about their status, they're still going to be subject to the same review and whether by the court. So I'm not sure that that green language that's currently in the draft adds anything and is necessary. As far as when you go down and you then look at the section, find it there, on line 14, when you start getting into victims' rights in the yellow, it certainly victims have rights under Title 13. It's the rights under Title 13 in chapter 165, I believe it is, do not talk about these types of proceedings. So the expansion of victims' rights into the mental health arena is something that should be spelled out. And if that's the policy that the legislature wants to adopt, absolutely, spelling it out is helpful. When you go to the next section on the state's attorneys, subsection C.
Before you go there, Judge Zoney, so are you saying this is good that we're spelling it out here, or do we need to do something more?
Well, it's a change, because right now the victim would not, under the statutes, necessarily have a clear opportunity to receive those notices. And so I think that if that's the policy, then absolutely spelling it out lets everyone know this is the rights of the victims in this arena, where they previously would not have been having certain rights enumerated.
Thank you.
The section at the end of page 11 with the state's attorney, where that begins, this gets into the request for a discharge hearing. And again, it's a policy for the legislature to allow victims to ask for a discharge hearing and such. But the comment that I think is important is that when we start getting into timelines, where it talks about the hearing being held within 15 days, I think those types of timelines can become problematic. And I would suggest getting rid of the specific dates and putting in language about prompt. In other words, you can put in a time that the victim or whoever's going to request it has to request a discharge hearing. So right now it says they have to request a discharge hearing. It says to be held within 15 days. I can't tell if that means they have to request a discharge hearing within 15 days, or they have to request that the hearing itself is held within 15 days. I think there's a distinction between the two. So there's a lack of clarity as to what that means. And so I would suggest simply having it, they have to request a hearing within X days, period. The hearing shall be held. Once a hearing is requested, it shall be held promptly, as opposed to having that 10 days there. The court wants to have the hearings promptly within the shortest duration of time possible, but for a number of reasons, it might be difficult to meet that 10 days. And our current rules are a day is a day. So I can envision circumstances where it might be difficult to meet that 10 days. And the language about keeping the pending discharge stay, well, that preserves the status quo. And so it does provide for that to stay the way it is. And the final clause there talks about the victim is entitled to appear to provide their opinion as to whether the person shall be discharged. I think that first I would note where it says the person shall be discharged. I think the word should might be a better word there. But the question that I would have as a judge when I read this is, well, wait a minute. Does that mean they get to sit there in the hearing the entire time? Or does it mean that the victims will simply present their statement? And I would note, for instance, that under Title 33, under the rights of victims in delinquency proceedings, Section 5234A clearly spells out what their rights are. And so what I would suggest is whatever rights that the committee and the legislature decides that the victim should have, is it to, and whether it's to make a statement and stay for the entire hearing, or make a statement and not stay for the entire hearing, it might be helpful to spell that out, because the victims should know what their rights are up front. And under 5234A, subsection A4 says that the victims in delinquencies have the right to attend the hearing for the sole purpose of presenting to the court a victim impact statement, including testimony in support of the claim for restitution. And then it goes on to say the victim shall not be personally present at any portion of the disposition hearing except to present a victim impact statement or to testify in support of the claim for restitution, unless the court finds that the victim's presence is necessary in the interest of justice. And I just note that language only because it represents a clarity for the judges to be able to follow, to know exactly what the victim's rights, because what we don't want to have are victims who are coming to a hearing expecting that they're going to be able to be there for the entire hearing, having an objection made that they should only be there for a statement, and having the judge have to decide that. And reasonably speaking, when we have 36 judges, you might get judges who view that statute differently. And so I think clarity and predictability would be helpful there.
So what was the citation, 5244A, or I may have gotten it wrong?
Title 33, 5234 small a.
Okay, thank you.
And it's under subsection A4. And again, I'm not saying that that is what I'm recommending you adopt. I'm pointing that out simply as something that I know the legislature worked on last year to make sure that victims had rights. And it was very clear to avoid, I think, this type of potential contention as to what is really intended. The section on subsection D on page 12 at line 8, the criminal division does maintain the jurisdiction over the case. And so whether that's stated or not, that's going to remain the case as far as the charge, because that's the criminal division under our statutes is where those charges lie. Likewise, that's where decisions about bail and conditions of release also remain. There is in S91 language that is somewhat similar to this under the competency bill. And so I've been trying to wrestle with, is it necessary in this bill to repeat that the conditions of release and hold without or other bail decisions remain in place when it might be in another bill, but that one of the bills might get signed and the other one might not. So I just point that out, that you would want to make sure that they are reconciled and are consistent. And those were, and I think that about hits the comments that I wanted to make. And again, and I would note also that when you talk about the prompt decisions, that the prompt hearing and things like that, it can be difficult at times to meet those decisions, and certainly judges want to issue decisions in a timely manner. And so when you put in timelines for holding hearings, we recognize that we need to get, especially in important cases like this, we need to get the decisions out quickly. And so that's something that I think when there may be suggestions, well, why don't we say judges need to issue a decision within X amount of time? I would urge caution in considerations like that, because I think that does raise what would reasonably be viewed as separation of powers issues. Judicial decision timelines are generally within the purview of the judiciary as far as getting them out, but we do have guidelines, and I can assure you that if the statute were to be passed and enacted on cases like this, the judges would be well aware of the importance of issuing decisions that I think everyone on this committee would agree were very timely.
Any questions for Judge Zoney? Joe?
Thank you, Judge Zoney. This is very helpful. Just a couple of questions. My first question is on page 11, lines 3 through 6. We've added in this language about the evidence of the guilt being great. The concern being, as you've heard in my previous question, about ensuring that if a person is going to be placed in a facility where there is a higher level of restraint involved, and that facility is only applicable to those who are accused of crimes, that there is some sort of finding about that there's the evidence of guilt is great, that they actually committed that crime, and we're not sending someone there, there's not a high evidence of guilt. So I'm wondering your feelings about that language, if it's in an appropriate place, and things like that.
Well, this section, even though the idea is it's for people who with crimes, again, this provision appears in the general applicability provisions under Title 18. So when you're looking at the general provisions, it would seemingly apply to individuals who were not charged with crimes also. So having this type of language in here can set those individuals apart. The question I have is, what do you mean by evidence of guilt if the crime is great? Are we enacting what we would call a Rule 12D or a Rule 29 standard? And that's what it sounds like. And so I don't know that this language, that criteria is actually necessary, because the court is still going to have to find that this individual needs this level of care and that it is the least restrictive setting adequate to meet their needs. Whether evidence of guilt is great or anything else, if that's the least restrictive setting, it's the least restrictive setting. And that's where they should be.
That makes sense. You were just saying about sort of the general applicability. Could you just point me to that? Because I wasn't sure.
What I mean is that Section 7618 is in the Title 18 statutes under mental health. And so the Title 18, that the 7618 falls within, it's not just criminal cases that would be applied under that. It applies with the civil commitment cases also. It's a structured set of statutes in Title 18 that address the civil commitment, and what happens under 4822 in our under Title 13, our criminal statutes, we reference into that.
Thanks. My other question was on page 11, lines 7 through 8. It mentions this idea that the court may at any time on its own motion or motion of an interested party review the need for treatment at a forensic facility. Do you think that language is enough, or that needs to be spelled out more exactly what that entails?
What I think it means, and I think my thought about the intent is that what it means is the court can essentially begin what we would call a discharge proceeding, because it would seem that what the legislature would not be wanting to have happen is, well, there's a process for the victims to get notice, for the state and everyone to understand what's going to happen for discharge, put everyone on it, and we have these hearings and go through the process. Unless the judge decides that he or she or an interested party wants to have a discharge, and then we'll just do it differently. So I think it may be helpful to add some clarity there, to say that the court may at any time or on its own motion or on motion of an interested party review the need for treatment at the forensic facility. The court shall conduct proceedings consistent with or in accordance with, and you can reference how you want the judge to handle that at that time. And you could tie that into the discharge proceedings, because again, what you don't want to do is have a situation where there's if you will, a workaround to the notice and ability of everyone to participate.
That's what I was worried about, because it felt very loose, that section, and I wasn't sure if there was another thing that might refer to, but I agree it could sort of cross-reference this if we go in the direction of 7618A, maybe a cross-reference or something. Thank you.
Barbara.
So Judge Zoney, I am wondering if you can say what page you were referring to when you shared that you thought specifying a number of days for the court was an issue. And
As far as the timing of decisions, it's not in here. I'm just suggesting that that's
Okay.
something we want to keep in mind.
okay, because I was thinking about what you said about the overreach, and it looks like, I mean, we frequently say after being arrested, a hearing will occur within 24 hours. And so I wondered about that. And I get nervous about it just saying will happen promptly, because I think one of the things that promptly just will mean something different to everybody. And it's like, well, it is promptly given this or given that. And so I wondered about language such something like within a reasonable time period, but not later than blank days or something, so that we're trying to you make it more sort of consistent how often like somebody's court hearing has to occur.
I absolutely, please don't hear me to be saying that it's inappropriate to set timelines for what hearings.
Okay.
That's fine. What I'm saying is, if you say, well, Judge, you had a hearing on this date, you have to give us a decision within 6 hours. That something like that is different.
Right.
As far as
Okay.
timelines, if you're going to have a timeline in here, and I understand the reason why, because it's important to have everyone on the same page that we just can't let things languish and we can't have them out.
Right.
What I would suggest is that if it says, for instance, may request a discharge hearing within 15 days, may file a request for a discharge hearing within 15 days, period. Or what I would suggest is you might want to change that to fit 10 days. In other words, say they have to file their request within 10 days.
Right.
And then once a hearing is requested, it shall be held within 15 days and the pending discharge. If you flip them, I think that increases the ability of the court to conform. And I would suggest adding language that says shall be held within 10 days. And you could add a line that says 15 days. And then perhaps you can add a line that says something about unless good cause is shown for an extension, not to, and if you want to put a timeline, not to exceed X days, something like that.
Okay, thank you. That's helpful. I have one more question. Sorry. So it was also very helpful when you gave the feedback now about victim shall versus victim should. And if they're sitting through the whole procedure, another witness, we've heard from so many people, talked about what the family or the victim is offering in terms of information related to if the person is a danger, and if that information is based on the initial incident or some new information. And I wondered if you had any, and again, I'm going to look at the statute you cited for what the legislature has done in order for victims to have their rights implemented. But I'm wondering if you have any insight into what victims have offered in terms of input, if it's mostly related to danger or other, like what your experience has been in terms of what that meaningful input is that the court can use.
I think that we would generally hear such information in a sentencing hearing, oftentimes when a victim is speaking. And the statements oftentimes are not sworn. And I think it's safe to say that they inform the judge's decision as to the views of the victim so that the judge can fully consider them when he or she is deciding on the weighing out of the evidence and the appropriate sentence. It's important information for judges to have. And it goes to the very essence of what the judge is, when the judge is throwing it all together in his or her mind and deciding what's the appropriate outcome in this case. I think it goes to the weight that the judge affords certain aspects of it, and the judge would consider it.
Thank you. I mean, and I know in these cases it's different because it's not really sentencing. So again, it's not raising victims' expectations about something that may not be taken into consideration because there were other considerations that sort of trump that.
Again, I think it goes to the totality of what the judge is considering and the weight that the judge is going to give the various information.
Thanks.
Thank you very much, Judge Zone. I really appreciate it. And so as follow-up, I believe I've requested, and hopefully I'll repeat the request that for Jared and Stuart and Karen and I would rope in somebody from Defender General's office as well to try to get the language straightened out, that we have multiple versions. And now we have some input from Judge Zone as well on the section that starts at the subdivision that starts at the bottom of page 11, subsection C, and goes on to the next page. And if at all possible, if we can have that recommendation by the end of the day, that would be great, or by tomorrow morning. So, but with those working pieces together, we'll be able to hopefully reconcile the three versions plus Judge Zone's input. So we're going to just take a 10-minute break, and then we're going to start a walkthrough of S4. And then